Attorney-client privilege, Bar 2008. 1. The following is the applicable provision under Rule 130 involving privileged communications between an attorney and his client, SEC 24. Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases: A. XXX. An attorney cannot, without the consent of his client, be examined as to any communication made by the client to him, or his advice given thereon in the course of, or with a view to, professional employment, nor can an attorney's secretary, stenographer, or clerk be examined, without the consent of the client and his employer, concerning any fact the knowledge of which has been acquired in such capacity. 2. The following requisites must be present for the privilege to arise. A. There must be a communication made by the client to the attorney, or an advice given by the attorney to his client. B. The communication or advice must be given in confidence, and C. The communication or advice must be given either in the course of the professional employment or with a view to professional employment. 3. The present rules do not require a perfected attorney-client relationship for the privilege to exist. The communications between the attorney and the client no longer need to be in the course of an actual professional employment. It is enough that the communication or advice be with a view to professional employment. Sec. 24b, Rule 130, Rules of Court. Hence, the privilege is extended to communications made for the purpose of securing the services of counsel even if the counsel later refuses the professional relationship. The insertion of the clause "with a view to" includes preliminary negotiations within the privilege. Without the clause, it would seem extremely risky to consult an attorney for the first time and communicate to him certain sensitive information without the protection of confidentiality. 4. Accordingly, the privilege is not confined to communications regarding actual pending cases. The communications may refer to anticipated litigations or may not refer to any litigation at all. It is sufficient that the statements be made in the course of legitimate professional relationship between the attorney and the client. Jones on Evidence, Volume 3, Section 749. The communication may be oral or written but is deemed to extend to other forms of conduct, like physical demonstration, as long as they are intended to be confidential. It is, likewise, submitted that the communication between a client and his lawyer is not deemed lacking in confidentiality solely because the communication is transmitted by facsimile, cellular telephone, or other electronic means. 5. It is commonly acknowledged that the privilege does not extend to communications where the client's purpose is the furtherance of a future intended crime or fraud. 8 Wigmore, Evidence, Sections 2298, 2299, McNaughton-Reeve 1961, Gardner, The Crime of Fraud Exception to the Attorney-Client Privilege, 47 ABAJ.708, or for the purpose of committing a crime or a tort. U.S. v. Wilson, 798 F2D 509, 1st CIR 1986, or those made in furtherance of illicit activity. U.S. v. O'Coin, 964 F2D 1492, 5th CIR 1992. Accordingly, although communications made when used to further crimes are not privileged, the discussion of the communications in confidence with the lawyer after the crime has been committed may still be privileged even though the earlier ones were not. In Re Federal Grand Jury Proceedings 89-10, MIA, 938 F2D 1578, 11th CIR 1991. 6. The statements of the client need not be made to the attorney in person. Those made to the attorney's secretary, clerk, or stenographer for transmission to the attorney for the purpose of the professional relationship, or with a view to such relationship, or those knowledge acquired by such employees in such capacity are covered by the privilege. Like the attorney, their employer, these persons cannot be examined as to the communication made by the client or the advice given by the attorney without the client's consent and also the employer's consent. Sec. 24b, Rule 130, Rules of Court. 7. A lawyer is bound to comply with Canon 21 of the Code of Professional Responsibility, which states that, a lawyer shall preserve the confidences and secrets of his client even after the attorney-client relation is terminated. The reason for the prohibition is found in the relation of attorney and client, which is one of trust and confidence of the highest degree. A lawyer becomes familiar with all the facts connected with his client's case. He learns from his client the weak points of the action as well as the strong ones. Such knowledge must be considered sacred and guarded with care. Samala v. Valencia, 512 SCRA 1, Mercado v. Vitriolo, 459 SCRA 1. Physician-patient privilege, Bar 1998. 1. The privileged communication between a physician and his patient is stated as follows in SACO 24 of Rule 130, SEC. 240 Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases: A. XXX, B. XXX, C. A person authorized to practice medicine, surgery or obstetrics cannot in a civil case, without the consent of the patient, be examined as to any advice or treatment given by him or any information which he may have acquired in attending such patient in a professional capacity, which information was necessary to enable him to act in that capacity, and which would blacken the reputation of the patient. XXX2. This privilege, embodied in Sec. 24 C of Rule 130, applies to a civil case whether the patient is a party or not. The phraseology of the rule implies that the privilege cannot be claimed in a criminal case, presumably because the interest of the public in criminal prosecution should be deemed more important than the secrecy of the communication. 3. Accordingly, this privilege protects the interest of the patient. It is designed to promote health, not truth. It encourages free disclosure in the sickroom by preventing disclosure in the courtroom. The patient is the person to be encouraged and he is the holder of the privilege. Metropolitan Life and Insurance Co. v. Kaufman, 104:13, 87 P2D 758 in McCormick, Evidence, Section 102. 4. The person against whom the privilege is claimed is a person duly authorized to practice medicine, surgery, or obstetrics. The information which cannot be disclosed refers to A. Any advice given to the client, B. Any treatment given to the client, C. Any information acquired in attending such patient provided that the advice, treatment or information was made or acquired in a professional capacity and was necessary to enable him to act in that capacity, and D. The information sought to be disclosed would tend to blacken the reputation of the patient. Sec. 24 C. Rule 130, Rules of Court. The word reputation is used instead of the previous word character. 5. Also, it is opined that the rule does not require that the relationship between the physician and the patient be a result of a contractual relationship. It could be the result of a quasi-contractual relationship, as when the patient is seriously ill and the physician treats him even if he is not in a condition to give his consent, as in the situation described in Art. 2167 of the Civil Code of the Philippines. 6. The privilege does not apply to shield the commission of a crime or when the purpose is an unlawful one, as to obtain narcotics or prohibited drugs in violation of law, because there is no treatment involved. Similarly, where the purpose is to ask a physician to have one's appearance disguised by cosmetic or plastic surgery to escape apprehension, the privilege does not apply. Common reason suggests that all these cases be deemed outside the operation of the privilege because the purpose is not for treatment or prevention of any disease or injury. 7. The privilege survives the death of the patient. Death does not permit the living to impair the deceased's name by disclosing communications held confidential by law. Thus, in Gonzalez v. Court of Appeals 298 SCRA 322, the Supreme Court prevented the disclosure of medical findings that would tend to blacken the reputation of the patient even after his death. 8. The privilege may be waived by the patient. The waiver may be made expressly or impliedly. The waiver may be by a contract, as in medical or life insurance. When there is disclosure by the patient of the information, there is necessarily a waiver. When the patient answers questions on matters which are supposedly privileged on cross-examination, the waiver also exists. There could also be a waiver by operation of law or the rules. Under Rule 28 of the Rules of Court, the court in which the action is pending may, in its discretion, order a party to submit to a physical or mental examination. Sec. 1 Rule 28, Rules of Court. This happens when the mental or physical condition of a party is in dispute. The party examined may request a report of the examination. By doing so, he waives any privilege he may have in that action regarding the testimony of every other person who has examined him in respect of the same examination. Sec. 4 Rule 28, Rules of Court. Priest, minister-penitent privilege. 1. Another privileged communication under the rules is as follows: SEC. 24. Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases: XXX-D. A minister or priest cannot, without the consent of the person making the confession, be examined as to any confession made to or any advice given by him in his professional character in the course of discipline enjoined by the church to which the priest or minister or priest belongs. XXX. 2. The person making the confession holds the privilege, and the priest or minister hearing the confession in his professional capacity is prohibited from making a disclosure of the confession without the consent of the person confessing. The privilege also extends not only to a confession made by the penitent but also to any advice given by the minister or priest. The confession and the advice must be made or given pursuant to the course of discipline of the denomination or sect to which the minister or priest belongs. Sec. 24d, Rule 130, Rules of Court. Thus, the minister or priest must be duly ordained or consecrated by his sect. 3. Not every communication made to a minister or priest is privileged. The communication must be made pursuant to confessions of sins. Wigmore on Evidence, Section 848. As clearly provided in the rule, the advice given as a result of the confession must be made in the minister's professional character. Sec. 24d, Rule 130, Rules of Court, or in his spiritual capacity. Accordingly, where the penitent discussed business arrangements with the priest, the privilege does not apply. U.S. v. Gordon, 493 F. Sup. .822, 7th CIR 1987. Privileged communications to public officers. 1. As to privileged communications to public officers, the relevant rule declares, SEC. 24 grams disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases: XXXE. A public officer cannot be examined during his term of office or afterwards, as to communications made to him in official confidence, when the court finds that the public interest would suffer by the disclosure. 2. Under the above rule, communications made to a public officer in official confidence are privileged when the court finds that the disclosure would adversely affect the public interest. It is the interest of the public that is sought to be protected by the rule, hence, the disclosure or non-disclosure is not dependent on the will of the officer but on the determination by a competent court. The privilege may be invoked not only during the term of office of the public officer but also afterwards. Sec. 24e, Rule 130, Rules of Court. 3. National security matters and state secrets are, of course, confidential and a court will most likely uphold the privilege. A society may not always be able to conduct its business with total openness and matters affecting national interest must not be divulged. Guang v. U.S. 860 F2D 1063 Fed. CIR 1988. Executive privilege, presidential communications privilege. 1. The concept of executive privilege and its origins were elucidated in sufficient detail in Senate of the Philippines v. Ermita 488 SCRA 1. In relation to its American origins, the privilege has been described as the power of the government to withhold information from the public, the courts, and the Congress. 2. The doctrine of executive privilege found recognition in the 1995 case of Almonte v. Vasquez 244 SCRA 286. Here, the court acknowledged that there are certain types of information which the government may withhold from the public like military, diplomatic and national security secrets. Alluding to foreign jurisprudence, it was ruled that the president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions and to do so in a way many would be unwilling to express except privately. 3. Chavez v. PCGG 299 SCRA 744 ruled that there is a privilege against disclosure on certain matters involving state secrets regarding the following: A. Military, B. Diplomatic, and C. Other national security matters. Again, in Chavez v. Public Estates Authority 384 SCRA 152, it was similarly held that secrets involving military, diplomatic, and national security matters, and information on investigations of crimes by law enforcement agencies before the prosecution of the accused were exempted from the right to information. The right to information does not also extend to presidential conversations, correspondences, and discussions in closed-door cabinet meetings. 4. The Constitution of the Philippines recognizes the right of the people to information on matters of public concern and guarantees access to official records, documents, and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, subject to such limitations as may be provided by law. Sec. 7, Art.111, Bill of Rights, Constitution of the Philippines. What matters may be disclosed in relation to the right to information on matters of public concern? This was actually one of the issues sought to be resolved in v. Aquino, 558 SCRA 468. The petitioners in the case, a tapestry of various personalities like citizens, taxpayers, congressmen including non-government organizations, sought via a petition for mandamus and prohibition to obtain from respondents in the persons of various government functionaries, the full text of the Japan-Philippines Economic Partnership Agreement (JPEPA), information which the government previously refused to disclose. The petitioners assert among others, that the refusal of the government to disclose the documents bearing on the JPEPA violates their right to information on matters of public concern, and contravenes other constitutional provisions on transparency, such as the policy of full disclosure of all transactions involving public interest. They likewise posit that non-disclosure of the documents undermines their right to effective and reasonable participation in all levels of social, political and economic decision-making. Respondents do not dispute that the JPEPA, as an international trade agreement, is a matter of public concern, but they claim that a full disclosure of matters would involve disclosure of diplomatic negotiations which were then in progress. They assert that diplomatic negotiations are covered by the doctrine of executive privilege, thus constituting an exception to the right to information and the policy of full public disclosure. In resolving the conflicting claims of the parties, the court first affirmed what it termed the well-established jurisprudence that neither the right to information nor the policy of full disclosure is absolute, there being matters which, albeit of matters of public concern or public interest, are recognized as privileged in nature. The court reiterated what it held in previous cases, that the information on intergovernment exchanges prior to the conclusion of treaties and executive agreements may be subject to reasonable safeguards for the sake of national interest. The court held that while the final text of the JPEPA may not be left perpetually confidential since there is a need to discuss the same before it is approved, the offers exchanged by the parties during the negotiations continue to be privileged, even after the JPEPA is published. Disclosing these exchanges could impair the ability of the Philippines to deal not only with Japan but with other foreign governments in future negotiations. Reminding the parties of what it had declared in Chavez v. PCGG 299 SCRA 744, that while the constitutional right to information includes official information on ongoing negotiations before a final contract, such information does not cover recognized exceptions like privileged information, military and diplomatic secrets and similar matters affecting national interest. The matters falling under these exceptions, according to the court, cannot be disclosed even if they constitute definite propositions. Since diplomatic negotiations enjoy a presumptive privilege against disclosure, petitioners need to sufficiently show the existence of a public interest sufficient to overcome the privilege. The court concluded with a finding that the petitioners have failed to present a sufficient showing of need in their arguments. 5. An earlier case, Neri v. Senate Committees on Accountability of Public Officers and Investigations 435 SCRA 110, 148, similarly demonstrates the extent of the right to information on matters alleged to be of public concern. Romulo Neri, the petitioner in this case, as then director of the NEDA, was accordingly said to have discussed with the President of the Philippines regarding the ZTE-NBN deal. The petitioner, upon invitation of the respondents, Senate Committee on Accountability of Public Officers and Investigations, Senate Committee on Trade and Commerce, and Senate Committee on National Defense and Security, testified on the ZTE-NBN contract and the bribe offers in connection with the deal. When asked on the details of the matters he discussed with the president after he divulged to the latter the bribe offers, petitioner declined to disclose the details of their conversation, invoking the privileged nature of the conversation on specifically the following matters: a. Whether the president followed up the NBN project, b. Whether Neri was dictated upon to follow up the project, and c. Whether the president said to go ahead and approve the project after being told of the alleged bribe. The court, in deciding the case, started with the premise recognizing the power of Congress to conduct inquiries in aid of legislation, a power which extends even to public officials. The only way for them to be exempted from the compulsory process of congressional subpoena is through a valid claim of executive privilege. The court declared it was convinced that the communications elicited by the 3 questions are covered by the presidential communication privilege. The Neri case emphasized the rule that for the claim of executive privilege to be invoked, there must be a formal claim of the privilege, lodged by the head of the department which has control of the matter, and that a formal and proper claim of the privilege requires a precise and certain reason for preserving confidentiality, but Congress must not require the executive to state the reasons for the claim with such particularity as to compel the disclosure of the information which the privilege is meant to protect. This is a matter of respect for a coordinate and co-equal department. It was ruled that the letter of Secretary Ermita to the respondent satisfies the requirement. Privileged communications under the rules on electronic evidence. Privileged communications apply even to electronic evidence. Under Sec. 3, Rule 3 of the Rules on Electronic Evidence, the confidential character of a privileged communication is not lost solely on the ground that it is in the form of an electronic document. Parental and filial privilege, Bar 1998. 1. Two privileges are embodied in Sec. 25 of Rule 130, namely a. the parental privilege rule, and b. the filial privilege rule. Under the parental privilege rule, a parent cannot be compelled to testify against his child or other direct descendants. Under the filial privilege rule, a child may not be compelled to testify against his parents or other direct descendants. 2. A person, however, may testify against his parents or children voluntarily, but if he refuses to do so, the rule protects him from any compulsion. Said rule applies to both criminal and civil cases since the rule makes no distinction. Sec. 25 Rule 130, Rules of Court. The rule states, Sec. 25. Parental and filial privilege. No person may be compelled to testify against his parents, other direct descendants, children or other direct descendants. 3. In criminal cases, the Family Code of the Philippines lays down, as a general rule, a policy substantially similar to Sec. 25, Rule 130 of the Rules of Court. Under the Family Code, no descendant shall be compelled, in a criminal case, to testify against his parents and grandparents. The Code, however, specifically provides for an exception. The descendant may be compelled to give his testimony in the following instances. A. When such testimony is indispensable in a crime committed against said descendant, or b. in a crime committed by one parent against the other. Art. 215, Family Code of the Philippines. The relevant article provides. Art. 215b. No descendant shall be compelled, in a criminal case, to testify against his parents and grandparents, except when such testimony is indispensable in a crime, against the descendant or by one parent against the other.